I am Sonny Roy reporting the 10 alleged fraud upon the court after nearly 7 years of intense suffering, nearly 7 years of mental anguish, 7 years of severe financial hardships. We find it necessary to bring this to you, the public, so for your own investigation and your own opinion. I am your host, Sonny Roy, and I am a pro se plaintiff. Fraud upon the court, number 1, as alleged. The explosive and unauthorized appearance of an attorney who has been withdrawn, terminated since 2009, yet accepted, and his motions acted upon by the lower court unbeknown to us and not authorized by us, to our detriment. Alleged fraud upon the court, number 2. The abortion of 2 scheduled jury trials, final orders on the record, but aborted unbeknown to us and to our detriment. Alleged fraud upon the court, number 3. The execution of a summary judgment with disputed material facts on the record, yet later on metamorphosed as irrelevant issues. Alleged fraud upon the court, number 4. The acceptance of the rescission of a staple letter, which is central to our property rights case. The letter was predicted, investigated, reviewed, analyzed, written, issued, mismailed to the wrong address, and later on rescinded for fear of the consequences. Alleged fraud upon the court, number 5. No evidence on the record, no evidence. The dismissal with prejudice of a commissioner who contained vital information in his hand that can make or break this case. Alleged fraud upon the court, number 6. No evidence on the record. A $55,000 that was imposed on plaintiff as recreational fees, which recreations the Wharton County never intended to give because they have issued 3 stop work orders within 12 months for the same reasons, to make sure that their intent is well spelled out. They did not want plaintiffs to have his properties, so they made sure they issued 3 for the same reason. Alleged fraud upon the court, number 7. The elimination to extinction of all takings torts, in this case, takings that the lower court has analyzed and has promised to revisit when the takings are ripe. But the lower court closed the case to the detriment of the plaintiff without analyzing the takings. Alleged fraud upon the court, number 8. The elimination to extinction of all the discrimination torts in a area that is historically racially segregated, as admitted and conveyed by the lower court, to the detriment of plaintiffs that were trapped in a hostile environment. Alleged fraud upon the court, number 9. The prejudicial oversight by the court for nearly 1 year. This case went to court in 2006, and the case was not visited again until 2007, and upon the plaintiff's request, because their real estate broker has died suddenly in an airplane crash, to the detriment of plaintiff. Alleged fraud upon the court number 10, the refusal to allow Rule 60 to reopen this case and to give plaintiff, to give all the facts and all the evidence proper course in this case that is unprecedented. This is unheard of. Ladies and gentlemen, we, the plaintiffs, and millions of people in this country, we expected much more from the great courts. We expected much more from this process. We have not seen justice, neither have we seen the appearance of justice as demanded by the United States Supreme Court. Therefore, we appeal to the great authorities of this land, to the great United States Supreme Court. We appeal to the Honorable President of the United States, whose quotes have been an integral part of this whole proceedings. This is by no means to disparage the image of our great country. Rather, it is the democratic process that serves to purify our system, to make it something that is unequal and second to none. It is a sign that we need continuous improvement. And we, as the plaintiff, want this case to be like a case that is in a lab work, a subject of analysis for the public to know, for the country to know, and for the great men and women in authorities to see and to execute judgment accordingly. May God bless this great country. May God bless the United States of America. Thank you.